Major national policy decisions must be made by Congress, not delegated by Congress to the executive branch. A big difference, huge difference.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
Okay, so Justice Kavanaugh said something really interesting this week, and I don't know if it's really interesting good or really interesting bad, because I'm a lawyer and I evaluate these things and decide how I feel afterwards, not before. So I wanted to go over this case first, because this is the progenitor of what we're about to read, and what we're about to read is only 2 pages long, so if I read it right out the gate, then you're just gonna leave, and I can't have that. I gotta have you like watch something first. So this is Gundy versus United States, which was a 2019, or it was decided in 2019 by the Supreme Court, and it was part of SORNA, which you can read what that is. I am not going to read those words because YouTube will just kick me off the platform completely, and I will never get a dime from YouTube ever again. Herman Avery Gundy was on supervised release for a federal offense. He had been sentenced to 20 years of imprisonment, 5 years probation, and 10 years was suspended. That means as long as he keeps his nose clean, he won't have to serve the other 10 years. Consequently, he was convicted of violating his supervised release. What did I just say? After he served his prison sentence, he was transferred to federal custody. So he was in state custody, then he was transferred to federal custody. He received permission to travel unsupervised to a residential reentry center in New York. He was released from custody, did not register as he was supposed to, and was thus arrested for not registering, violating SORNA. And he was indicted for that offense. So the controversy in this case is that he was convicted for the offense before SORNA was actually implemented, which means that it should not apply to him. So does the law retroactively apply to him? The law says the Attorney General shall have the authority to specify the applicability of requirements of this chapter to convicts before the enactment of this chapter or its implementation, and to prescribe rules for the registration of any offenders who are unable to comply with subsection B. So the Attorney General has decided that this law is applicable to everyone, making the law retroactive. So he filed a motion to dismiss. The Southern District of New York granted the motion. The prosecution appealed the dismissal. The appeals court for the Second Circuit disagreed and sent it back.
I will send it back.
Okay, then.
They sent it back. After a bench trial, the district court found him guilty. He was sentenced to time served and 5 years of supervised release. He appealed. The Court of Appeals ruled that he had participated voluntarily in interstate travel and was therefore required to register under SORNA. As he failed to do so, he was subject to sentencing as done by the district court. The court rejected his argument that the delegation of authority to the Attorney General violated the non-delegation clause based on circuit precedent. In 2017, then, he petitioned for a writ of certiorari to the Supreme Court. The Supreme Court granted certiorari, but limited to the question of the non-delegation or delegation of authority to the Attorney General, and whether that violates the non-delegation doctrine, which we'll get to in a moment. And so the majority decided then that the SORNA Act does not violate the non-delegation doctrine. The section of the SORNA that allows the Attorney General to specify the applicability of the mandatory registration requirements for convicts before the enactment of SORNA is constitutional because Congress can delegate legislative power to the executive branch if it provides an intelligible principle as guidance. The outcome of the case could have greatly influenced the broad delegations of power Congress has made to the federal executive branch, but it did not. And that's a bit of foreshadowing there, that last sentence. Let's read it again. The outcome of the case could have greatly influenced the broad delegations of power Congress has made to the federal executive branch through agency law. Whenever Congress makes an act that creates a new agency, like the FBI, like SORNA, like the FTC, like the IRS, whatever, they have to have some basis for doing so, and they have to delegate under certain rules. notice and comment period for rulemaking, or rather, that's the way that the agencies promulgate rules. Excuse me. They have to follow some rules when they are creating these things, and whether or not they have the power to delegate things that are given to the legislative branch, powers and duties that are given to the legislative branch under the Constitution, are they allowed to delegate some of those authorities? Well, if they're not allowed to delegate some of those authorities, well, they've been doing it an awful lot.
The list of federal agencies is huge. The legislature has granted some functions to the judicial branch, but the vast majority of administrative agencies exist in the executive branch, as you can see here. It's literally everything. The office of the president is a pretty obvious one, but then we get into the Department of Agriculture and the Department of Commerce and the Department of Defense, the entire Department of Defense, basically the entire military, the United States Department of Education, the Department of Energy, Health and Human Services, the Department of Homeland Security, Housing and Urban Development, Department of the Interior, Department of Justice, Department of Labor, Department of State, the Department of Transportation, the Department of Treasury, Veterans Affairs.
So if that's suddenly not constitutional, then a whole lot of things are not constitutional. So then enter Judge Kavanaugh. You might remember Justice Kavanaugh and the controversy from his appointment. Well, here is the case of Ronald Paul versus the United States on a petition for a writ of certiorari. This is the petition. Questions presented. The SORNA creates a federal duty to register for offenders who are required by state law. Mr. Paul was convicted of a qualifying state offense, but he later prevailed in state post-conviction proceedings and then settled with the state of Tennessee for a sentence of time served. So does he have to register is the question in that case. And so enter Judge Kavanaugh as they are denying certiorari. So this is denying certification to the Supreme Court. So the Supreme Court will not hear this case. And Justice Kavanaugh respects the denial of certiorari, and he writes, I agree with the denial of certiorari because this case ultimately raises the same statutory interpretation issue that the court resolved last term in Gundy versus United States. I write separately because Justice Gorsuch's scholarly analysis of the Constitution's non-delegation doctrine in his Gundy dissent, so that means the ones who wanted the non-delegation doctrine to prevail and for less delegation to occur. Justice Gorsuch's opinion builds on views expressed by then Justice Rehnquist some 40 years ago in Industrial Union Department, AFL-CIO, versus American Petroleum Institute. In that case, Justice Rehnquist opined that major national policy decisions must be made by Congress and the president in the legislative process, not delegated by Congress to the executive branch. A big difference, huge difference. In the wake of Justice Rehnquist's opinion, the court has not adopted a non-delegation principle for major questions, but the court has applied a closely related statutory interpretation doctrine. In order for an executive or independent agency to exercise regulatory authority over major policy questions of great economic and political importance, Congress must either, 1, expressly and specifically decide the major policy question themselves and delegate to the agency the authority to regulate and enforce, or 2, expressly and specifically delegate to the agency the authority to both decide the major policy question and to regulate and enforce. So in other words, if they don't do it clearly like that, It's basically void or voidable. The opinions of Justice Rehnquist and Justice Gorsuch would not allow that second category. Congressional delegations to agencies of authority to decide major policy questions. Even if Congress expressly and specifically delegates that authority, under their approach, Congress could delegate to agencies the authority to decide less major or fill up the details decisions. Like Justice Rehnquist's opinion 40 years ago, Justice Gorsuch's thoughtful Gundy opinion raised important points that may warrant further consideration in future cases. Now, that might not seem huge, but that is boom, that is mind-blowing, because there is a shift in the current Supreme Court of which political parties and what leanings the different judges have. Justice Ruth Bader Ginsburg is the opposite of Justice Kavanaugh in many senses, and she might be retiring or passing sometime soon. And if that happens, there will definitely be an opportunity for a further shift. And if there is such a shift, well, how would a justice go about saying so? They're not allowed to issue statements like this if the statements say, if I see this issue, I'm going to rule this way. No. He's just indicating, show me a case, because this is how we'll probably, this is what we're ready to reevaluate. He is basically asking for cases that deal with the non-delegation principle in order to further rule. And if the majority opinion comes down in one of these cases that these delegations have been ultra vires or outside of the legislative power, a whole bunch of stuff is going to have to be undone. And I really don't know how the court's going to even begin to handle that one. So this could be the beginning of a huge era, basically. If you've studied the Lochner era and how the Supreme Court had sort of an anti-workers' rights era, well, this could be a different era. This could be the era of Congress not being able to delegate major decisions to the executive branch. That's huge. That's huge. That could really be a good thing for the country if you think about it, or it might not be. It's a huge political discussion that we should start having. Hence, we're digging this video. So, love you all. Let us know what you think in the comments below. All right, here's the dissent. Maybe there's a summary. Justice Gorsuch, with whom the Chief Justice and Justice Thomas join, dissenting. The Constitution promises that only the people's elected representatives may adopt new federal laws restricting liberty. Yet the statute before us scrambles that design. It purports to endow the nation's chief prosecutor with the power to write his own criminal code governing the lives of 500,000 citizens. Yes, those affected are some of the least popular among us. But if a single executive branch official can write laws restricting the liberty of this group of persons, what does that mean for the next? Today, a plurality of an 8-member court endorses this extra constitutional arrangement, but resolves nothing. Working from an understanding of the Constitution at war with its text and history, the plurality reimagines the terms of the statute before us and insists there is nothing wrong with Congress handing off so much power to the Attorney General. But Justice Alito supplies the 5th vote for today's judgment, and he does not join either the plurality's constitutional or statutory analysis, indicating instead that he remains willing in a future case with a full court to revisit these matters. Respectfully, I would not wait. There's some foreshadowing for you. So convince Justice Alito, and you suddenly undo a lot of delegation to executive agencies, basically. Let us know what you think in the comments below. That is a bigger deal than it sounds. Those words carry a hell of a lot of weight.
There's some difference, too, between the types of groups that they're delegating to, right? I mean, you've got the FTC, which has a commission of people leading it, versus, say, the FBI, which has a single person.
Oh yeah,
you've got a single political appointee.
Please
so
don't
the application changes.
Yeah, please don't take me as an authority on what changes would have to be made. We would have to go through and have a really in-depth analysis of every agency Is it an executive agency? Is it a legislative agency? Is there such a thing as legislative agency? How was the power granted? Is it within the delegation doctrine, non-delegation doctrine? Is it in rule part 1, or was it in test 2, where it's a major policy decision? So we'd have to do this analysis for absolutely everything. I could not tell you if that means the IRS is properly created or not under the delegation or non-delegation doctrine. So, but that's really interesting that sort of Justice Kavanaugh has suggested there might be a kind of a coup, but it's the opposite of the kind of a coup that I thought Justice Kavanaugh would be responsible for, if you know what I mean. Like, I'm a different political persuasion than Justice Kavanaugh, so I assumed that he wouldn't want to return to proper principles of Congress governing the country, as opposed to Congress making laws and then saying, executive, go govern the country. And that is our show. Thank you for joining me. I am Leonard French, and this is Lawful Masses, your favorite legal news and story and education channel. Thank you very much to the contributors and supporters that make this channel possible. Thank you very much to our supporters on patreon.com/ljfrench and sponsus.com/law. Without your financial support, this channel would not be possible. Thank you very much to our $50 plus supporters in the month of November. Thank you to Joe Tyson, Aspernari, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, SnorreW, Blackleaf, Benjamin Hitov, and Steven. And thank you to the $5 plus supporters who are scrolling on the LED panel behind me and will be on the crawl in front of me. I will put some dog video up on the screen for you to enjoy while I am still speaking at you. I hope you had a great Thanksgiving, my friends in the US and abroad, and I look forward to a wonderful holiday season with you. I am Leonard French, your favorite copyright attorney. I will see you in the videos that drop. Love you all. Bye.